I call Dennis O'Rourke.
Mr Chairman, I want to talk about legal aid because access to justice is becoming more and more difficult. Costs are very high, even for relatively minor matters. Legal aid was, of course, designed to provide legal representation for people who could not afford it by themselves. It was never a grant, except to parties who could not afford to repay a legal services grant. And originally, the qualifying criteria made it possible for people at the lower end of the socio-economic scale and to access legal aid, and that worked very well. But now the criteria are so tough that very few people actually qualify. And I want to refer specifically to the legal services regulations as they now are, because it specifies that the maximum levels of income for the purpose of determining an applicant's eligibility for legal aid in respect of a civil matter are, and I quote, $22,366 per year for a single applicant, $35,420 per year for an applicant with a spouse or a partner or a dependent child, and $50,934 per year for an applicant with a spouse or partner and one dependent child, or two dependent children. So, Mr Chairman, that's a pretty low level, and it's even tougher when it comes to the maximum levels of disposable capital for the purposes of eligibility for legal aid. And it specifies for a civil matter that the maximum is $3,500, an incredibly low figure in my view. If the applicant has a spouse or partner, however, or one or more dependent children, the maximum level of disposable capital for that applicant is calculated by adding allowance of another $1,500. But even then, it's an incredibly low total. So, Mr Chairman, the income and capital thresholds for qualification for legal aid are now so low that many people will simply go unrepresented. And these are not wealthy people, just ordinary people who find it too tough to pay legal costs without some assistance. So the capital and income thresholds need urgent revision upwards so that people can get legal representation, because far too many are now forced for economic reasons to represent themselves. And that leads, of course, to poor quality justice. It leads to a greater burden of time on the courts. It leads to greater use of appeals, and it leads to more injustice than would be acceptable in a modern society. And Mr Chairman, to make matters worse, the Legal Aid Commissioner must now refuse legal aid if the applicant is in arrears for repayments on previous legal aid grants, subject to an interests of justice test. But nevertheless, the Commissioner's assessment about what is in the interests of justice can be very difficult, especially for unrepresented parties to argue successfully. And in addition to that, I actually don't personally trust the Commissioner's discretion on the interests of justice test in those circumstances. This provision, Mr Chairman, concerning arrears is intended to encourage legally aided people to start repaying their debt. And there's nothing wrong with that objective, but there is actually very little evidence to show that it is likely to have any positive effect on that objective at all. And the reason for that is perfectly obvious, and it's simply that the people in that position actually don't have the money to do the repayment of debt that is required of them. So it can't really have a positive effect in those circumstances. But what it does do is cause injustice by making legal aid unavailable in far too many cases, so that people either give up or have to represent themselves, and I've already spoken about the results of that. Mr Chairman, the Act saying that the amount owing is collectible as a debt and that should be enough is not sufficient in my view. That needs to be reviewed as well. In addition, we should be deleting the $50 user charge That is wrong. Many lawyers simply pay for that on behalf of their clients. Mr. Chairman, many lawyers simply pay for that on behalf of their client, and it really is just penny pinching on behalf of the state, and really isn't much more than a blatant attempt to try to suppress demand. And that, of course, is wrong in terms of what the Act is all about and what legal aid should be for. The money saved by the Crown would be very small if that user charge was abolished, but the effect on low-income people would be disproportionately high and very positive. And I'd like to turn next to the issue of interest on legal aid debt. That is absolutely wrong in principle in New Zealand First's view. Now, it is true that interest could be written off under the existing provisions in the Act, but it does require evidence of serious hardship, and the definition of serious hardship shows that it's a very high bar to reach, and as a result, of course, it will again be low-income people who will suffer. Not people at the very lowest rung, but people just above it, people who would nevertheless be badly affected by this particular provision, which I think is draconian. And the state, Mr. Chairman, should not be a banker in these matters, seeking interest at the rate of 8%. It should be seen as a public service, and there should be no interest charged on legal aid debt. Mr. Chairman, the government has lost its way as to what legal aid is really about, and it is really about access to justice, and that's what we're losing, and it's a very bad trend. Legal aid must be fair for people unable to afford a lawyer so that they can get sufficient assistance to take legal proceedings which have reasonable prospects of success, and to ensure assistance to people who have no choice but to defend proceedings brought against them. And many of them simply can't afford to do so because they can't get legal aid. So in the end, in its quest to move into surplus, this government, through its budget cuts over recent years for lower income people, the very people who need legal aid the most, are the ones who are going to suffer. The restrictions on legal aid, Mr. Chairman, have gone far too far, and combined with the increasing expense of the legal system and of legal costs generally, the result in far too many cases is that many people will be effectively priced out of the justice system. And I think, Mr. Chairman, that must change. This is a very serious issue, and I call on the government to look at legal aid, especially those three thresholds I referred to again, but the whole system. It really isn't working anymore for low-income people, and it's an urgent matter. It's an urgent matter that has not been addressed in this budget, and it needs to be looked at in the very near future.
I call Jen Logie.
Thank you,